I brought you back in here after you acted like that to listen to you. I've tried to explain it. You are not listening. I am done. Do not say another word to me.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If judge issues first warning you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned because this case escalates fast. We're in Washington County, Michigan, inside the courtroom of internet-famous Judge Cedric Simpson. And what starts as a routine pretrial hearing quickly turns into a legal powder keg. Multiple domestic violence cases, a knife allegation, and more than 100 prohibited phone calls from jail, all tied to the same victim. The prosecution says this is about safety in court orders being ignored. The defense says there's no physical evidence. And what no one expects, the alleged victim herself will soon storm into this I know the law moment courtroom and change the entire tone of the hearing. Buckle up. This one spirals fast.
The victim with the knife took it out while they were arguing, pulled it out, brought it down towards her.
But the problems don't end there. After his arrest, he was ordered not to have contact with the victim. But during the 3 days he was in jail,
while he was in custody from, I believe, 2-3 to 2-6, he made 135 calls to the victim, which was against the conditions of his bond, which was addressed at arraignment.
They were made using his unique PIN number. Attorney Zenda is now asking for more severe sanctions.
We have great concerns for her safety as he keeps contacting her and getting new cases for domestic violence with the same victim, and we would be asking that at this time his bond is set at $25,000 without the 10% into custody, Your Honor.
This moment is critical. Prosecutors aren't just arguing about the knife allegation anymore. They're focused on behavior after arrest. In the eyes of the court, those 135 jail calls matter because bond conditions are court orders, not suggestions. Even if the defense disputes intent, using a personal PIN to repeatedly contact the same protected individual raises serious red flags. Judges take no-contact violations extremely seriously, especially in domestic violence cases, because patterns matter. Here's the big question for you watching. If someone ignores court orders this many times, does the court have any choice but to tighten control? Or should allegations tension escalates fast always outweigh behavior?
The evidence is solely the testimony of the complaining witness. There has not been any evidence of a knife. Regarding the phone calls, my client does deny all of those allegations.
At this point, defendant's phone privileges, given what the court has heard, are revoked so that he'll go into the jail. He won't have phone privileges. But at this point, defendant's demanded. Ma'am, I'm going to let you know, if it weren't for the people in the prosecutor's office and counsel, I wouldn't be calling your case back up and you probably would have been locked up. I'm just going to let you know because you don't come into the court that way, ever. Am I clear?
Yes.
This is where courtroom procedure collides with raw emotion. The alleged judge loses patience. Victim isn't a defendant or an attorney, yet her actions directly impact how the court functions. Judge Simpson makes something very clear here. Courtrooms operate on rules, order, and process, not emotion. No matter how personal the situation feels, even when someone believes the record is inaccurate, there's a formal way to address it. Interrupting proceedings or challenging rulings emotionally can backfire fast. And it does here. Watch closely how the judge explains due process, preliminary findings, and why hearings exist. Do you think the court handled her concerns fairly? Or should there have been more flexibility given her role in the case? Courtroom shut down.
What did you want to tell the court, ma'am?
Okay, first I want to say I fully apologize for coming in here like that. I was unaware. I'm sorry. I just want you to know with this whole case, instead of incarcerating somebody,
Go ahead.
Y'all need to try to help him. I don't know if the prosecutor let you guys know, but he has a, yes, I'm sorry. You can talk. I don't want to overtalk you.
Well, you'll never do that. But I'm just going to let you know that I'm not going to sit here. You wanted to address something to the
Yes,
court.
because I feel like it was inaccurate.
I will listen to you. I'm not going to tell you or have you sit here and try to give me a lecture on how something should work.
Oh, no, I will never do that. But I just noticed when I was looking on the Zoom that it was inaccurate information stated on you guys' record, and I just fully disagree when inaccurate information is stated on something that's very important like this. With the prosecutors, they should have called me instead of giving out inaccurate information, because I would have just let you guys know. Instead, when I looked on that Zoom, it was inaccurate information stated on this, I don't know what you call, in this courtroom, and I just fully disagree with that, so I wanted to make that known.
Okay, let me just say this, because you kind of blurted that out when you had come busting in here.
And my apologies for
So let me just tell you so that you can understand what you're saying and what is being said. Because when you said that, which is everybody's obligation here, his counsel, the prosecutor, and even in some respects the court, to double check what somebody is saying, in particular if a decision was made based upon inaccurate information. Let me tell you that the prosecutor, as with her duty, checked what you were saying. I don't think, at least preliminarily, and I discussed it with his counsel and with the prosecutor, that what you're saying is correct, that it was inaccurate. At least with reference to what I was using for my decision on the remand. There will be a hearing that will be set next week. At that hearing, all of that will come out. But at least preliminarily, it does not look like the information that was presented to the court was in any way inaccurate. Some of the information with reference to the date, so that you understand, the court itself can tell in looking at the file and when he was arraigned. So while you may have your position that it's inaccurate, I do not believe at this time that it is inaccurate.
Okay, so is there any way that a prosecutor, someone can call my phone so we can discuss this? Because I no longer have that cell phone number, and it was to my sibling. You guys stated on.
If there are references to the case, ma'am, we thought about that.
Okay.
If there are references to the case, references to you, references to other things that are occurring. So I don't think, and I said, I have not made a final decision on it, certainly, but at least preliminarily, what is being represented to the court appears to be true. And we will flush it out at a hearing, because that's the way our system works. Preliminarily, I have that. I took what remedies need to be done to enforce the orders of the court regarding no contact. It seems that that was violated. He will have his due process right to a hearing next week regarding that.
But how is it violated when I have not physically talked to him? Just like when I came into the courtroom the first time and I sat down, he made it aware that I can't even be around him.
I am not going to have a hearing on it right now. I will listen to you.
That's just that was just very inaccurate to me, and I just felt like the way that y'all did that was no. Somebody should have.
Y'all did what? Don't you turn your back on me, because I'm telling you what, you are trying my patience.
No,
you are trying my patience. I brought you back in here after you acted like that to listen to you. And then you're not going to listen to a thing I said. I'm done. If you want to attend the hearing next week, you can come to the hearing. I've tried to explain it. You are not listening. I am done. Do not say another word to me. Mr. Allen, remove her.
Nobody.
Remove her. You keep talking and there's going to be a problem. There's going to be a problem.
In the end, this case comes down to one central issue: compliance. Regardless of disputed allegations, repeated violations of court orders, especially no-contact orders, carry real consequences. Judge Simpson's rulings reflect a system prioritizing safety, procedure, and due process over emotion and argument in the moment. With bonds denied again, Rashard Young now remains in custody until his preliminary examination, where the court will decide whether the evidence supports moving forward to trial. This case is a powerful reminder that courtroom rules apply to everyone, and ignoring them only narrows your options. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments and don't forget to subscribe for more jaw-dropping courtroom breakdowns.